Umkhonto weSizwe party will on Thursday challenge the legality of the Madlanga Commission of Inquiry. It's meant to start hearings on allegations of interference and corruption within the police service and the broader criminal justice system on Wednesday. The MKP spokesperson Nhlamulo Ndhlela joining us this evening to talk about all of these issues. Nhlamulo, good to have you on the SABC. So you're saying, for instance, that the Madlanga Commission sitting on Wednesday, when your matter is going to be heard or scheduled to be heard on Thursday, is reckless. How so?
Well, good evening to you, Tebigan, and good evening to your viewers. Look, as you know, we had taken this matter to the Constitutional Court, where on the basis of jurisdiction, it was said by the Constitutional Court judges that this matter should then be sent to the High Court, which is where we're at right now. We did state categorically that we're going to follow up on this matter. We then sent questions to the president, raising a number of issues as per his announcement. One of those being, when you're appointing this minister, is it a minister designate, or an acting minister? Over and above the fact that we stated that the judiciary off the back of the announcement by General Umkhonto was complicit and implicated. So how is it possible that you then set up a commission of inquiry, a judicial one in that case, when you know very well that the judicial commission of inquiry and the judiciary itself is in effect, complicit or implicated? Now, we're saying that this should be, by the court's rule to be invalid, unconstitutional, because there is no need for you to then bring a judicial commission of inquiry where a judge is going to have to preside over matters that implicate your peers. So we're saying that this is unconstitutional. And also, this Madlanga Commission was supposed to have started on the 1st of September. What's interesting, and it's not just as a matter of coincidence, you can tell that this is quite well orchestrated and planned, is you would know that we were given this date of the 18th and the 19th, where our case is going to be presided over by a full bench of 3 judges. But the Madlanga Commission leadership, or whoever it is that is responsible for the admin and the setting up of this whole process, then decided a day before. Now, we're saying, if they want to uphold the rule of law and they want to ensure that this process is beyond reproach, such decisions and the alignment of such a date before even the actual court proceedings take place, which is really 2 days, are very concerning, and they raise a flag. So we're saying that this is more than anything else, an agenda behind how it is that they come on a date just 2 days, a day before, a couple of hours before.
Do you have proof then of the idea that all of this is orchestrated when you look at the timeline? Because initially we were told the commission was not able to sit at the beginning of September because the Justice Department, which ultimately would have been responsible for sorting out the logistics, had not been able to meet the deadline then. And that's how we ended up with the postponement, which will result in the hearings beginning on Wednesday. If you're saying that is sinister, the process and the dates, do you have proof, or are we going on a feeling here?
Well, the facts at hand are glaring, isn't it? Because, as you say, from the first, with them knowing very well that we have a case on the 18th and the 19th, of which they themselves, in terms of their commission, are in effect affected.
Right.
So for them to choose a date, because they, remember, handpicked the date. It's not a date that was just conjured up. They went and handpicked a date off the back of a date that was given to us of the 18th and 19th. And they chose the 17th. They could have chosen the 21st. They could have chosen the 28th. Why not? So we're saying that itself is not a good look. And, these kind of things we actually need to take into consideration if there's going to be any conflict.
So if the commission, which it intends to do, sits Wednesday and your hearing with the High Court is on Thursday, how much harm do you think that 24 hours before the matter is heard will do to your case? How does it disadvantage the MKP's arguments?
I think that's a very good question. I mean, we could ask the same question to them. How much does it disadvantage the process if they've been able to wait for a good 16 days for them to wait until next week, Tuesday, for instance? I mean, it's an equal response and the same question that they would be asking us. We'd ask them, what's wrong with waiting for the outcomes of the court process and then, off the back of that, initiate this process?
But I'm asking you then, because you've already said it's reckless to do so, and I'm trying to understand what harm it would do, because let's say the court rules in your favor right after the hearing on Thursday, they would only be 1 day into the process, so not a lot of ground would have been covered. How do you think you'd be disadvantaged by that?
Well, remember, first and foremost, the South Africans are disadvantaged by the fact that there's 147 million rands that's been allocated to this process, which we've said categorically there's no need for a Madlanga Commission. We've got an ad hoc committee in Parliament. Parliamentarians are paid to preside over this, and more than anything else, more than competent, we believe, as lawmakers to preside over a state-owned department such as the police, and rightfully so, because we have oversight responsibility. So the ad hoc committee itself is enough of a process that is responsible, and rightly so within the law, to have oversight and to call upon all the witnesses to then account accordingly. The Madlanga Commission, as it is, it's a fruitless and wasteful expenditure process. It is a duplicate and a parallel process, of which is quite glaring in this country, because there's now a new shift and a wave of the judiciary now usurping power from Parliament. If you look at most cases that are out there where this Parliament takes decisions, it is the judiciary that usurps the powers of Parliament. So what we're seeing now is that, is an element of the judicial sovereignty more than that parliamentary process that is and should represent the people that elected members of Parliament.
Two things. You had taken issue at the beginning with the start of the process with Justice Madlanga, who was retiring at the time from the Constitutional Court, saying, how can he lead a process, and I'm paraphrasing here, that could possibly implicate colleagues, etc. He's now retired, so no longer a judge on the bench. Does that not deal with the issues that you had about the suitability then of a member of the judiciary leading the process? And secondly, on the issue of the ad hoc committee, how can you guarantee that it will be a more credible process when we know from Parliament's own history, partisan divisions have often, in fact, interfered with the very credibility of ad hoc committees and their ability to produce outcomes that are acceptable? A case in point would have been the Nkandla matter, which ultimately ended up, in fact, in the court system, and Parliament was found to have been foul in the processing of that chapter.
Well, let's not forget that judges are appointed by Mr. Phala himself. So this judge, in as much as you're saying that he's now retiring, those are still his peers. Whether we like it or not, he has worked with these people. There may be a relationship or still has a relationship with a lot of them. So we cannot now turn a blind eye to that. The issue of the ad hoc committee in Parliament, well, let's not forget that even the Section 89 report that still holds Mr. Phala, your president, accountable to, and says that there is an infringement on PRECA and that there's a case to be heard. There's still no outcome. Instead, you're finding, him using scapegoats of those that broke into his house today to try and cover up a huge, broader issue of his delinquency as a president. So we're saying that what needs to happen here, in as much as there's going to be an ad hoc committee in Parliament, and that parliamentarians, let's not forget, it has been stated, are also complicit in this and implicated. What we need to ensure is we need to sanitize the people that preside over this and ensure that those people, in actual fact, are not those that are actually complicit or have been called out and would then be found wanting as to why they're even participating in this process, because they're effectively to lose the credibility and the potency that it's supposed to have. Now, let's not also forget another key element here. And that key element is that the ad hoc committee itself need not be seen as a second-hand fiddle to the Madlanga Commission. It needs to be center-focused, and it needs to be the main platform where all recommendations by lawmakers comes out and its people are held accountable. And let's not forget that MK Party in the past was never part of any ad hoc committee. We're never in Parliament. Now we are. Now South Africans can also hold us accountable. We cannot respond on the basis of ad hoc committees where MK Party never participated.
Nhlamulo Ndhlela, good to talk to you. Thank you so much for your time as always and being on the SABC this evening.